Good evening, respected dignitaries and all the participants. I, Avneet Kaur, delegate of Sambhav Initiative and moderator for today's session. On behalf of organizing committee, I extend a very warm welcome to our esteemed dignitary, Ms. Priya Jain, Ms. Kakoli Nath ma'am, and Mr. Anirudh sir in 2 weeks online national capacity building program on criminal law, drafting procedure and trial from District Court to Supreme Court of India, jointly organized by Sambhav Initiative working towards alternative dispute resolution, free legal aid, and creating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice M.R. Shah sir, former Judge of Supreme Court of India, in collaboration with ProBono India, which is working towards legal aid and legal literacy. Today, we are truly privileged to have with us an exceptional panel from the Phenology Legal. Firstly, we have Ms. Priya Jain, the founder of Phenology Legal, a distinguished legal educator and entrepreneur who has transformed the way legal concepts are understood by the students across the country. With a massive digital presence, including over 4 million YouTube subscribers and 5 lakh plus Instagram followers, ma'am is widely known for simplifying constitutional law, landmark judgments, and exam strategies in a clear and impactful manner. We are also joined by Ms. Kakoli Nath ma'am, a passionate traveler and food enthusiast who serves as a legal content manager at Phenology Legal. Ma'am holds a master's degree in corporate law with specialization in intellectual property rights and brings valuable expertise as patent analyst, combining creativity with strong legal insight. And finally, we have Mr. Anirudh sir, who holds a bachelor's degree in law and brings practical experience in IPR, contract, and corporate law. As a skilled legal content writer, Sir is known for transforming complex legal topics into clear, engaging, and easy to understand insights, empowering readers through his work. We are deeply honored to have you with us today. Over to you, ma'am.
Thank you. Thank you so much for your kind words. Phenology Legal is nothing without the love of the students, without the comments of the students. So, the journey of Phenology Legal actually started from a lot of you enthusiastic students telling us through comment section what to do, what not to do. So, I remember back in 2018, I had no clue, no idea what to do. I just loved constitution and I wanted to teach constitution to the entire world. I was very passionate about education, so I just knew how to record videos, but what to do, what medium to choose. So one after the other, Abneet, I would like to tell you, one after the other comments started cropping up कि हम ना करंट अफेयर्स का कोर्स देख सकते हैं, हम ये कर सकते हैं, हम वो कर सकते हैं, एंड दैट गेव मी so much joy and so much passion towards it. तो मुझे लगता है कि if it wouldn't have been the enthusiasm of all the students, फिनोलॉजी लीगल का जो लाइफ साइकिल है वो बहुत छोटा होता. It would have been 2 to 3 years, but because of all the zeal that you all have, it's been a lovely journey. Right now we are a team of 40 people and all of us are mad about law. All of us are super passionate about education. So thank you for this community. Thank you for the Sambhav initiative that you thought we could contribute to it. So hello everyone, I am Priya from Phenology Legal. Today, we are going to understand some very important key fundamental topics of criminal law, which is FIR, complaint, role of prosecution and defense during investigation stage. So the challenge that we've kept for ourselves is not to just deliver you bookish knowledge, not to just tell you theoretical knowledge, because if you just do that, you're not going to go here and have something tangible that you can apply your brain to. So going to give you practical insights as well. Now, my area of specialization is constitutional law. But if I have any doubts in the criminal law area, I run to my colleagues Kakoli and Anirudh. So these two are going to take today's session. They are very passionate about criminal law and education and legal awareness in general. They are very, very, very fun. You're going to enjoy. I'm going to be here. If you have any doubts, do let me in the comment section and in the comment section only. And I'll get back to you. So over to Kakoli from now. Thank you. Thank you for having me here.
Thank you, Priya Jain madam, for motivating us and for your wonderful speech.
Thank you.
So, Okay. So, hi everyone. I am Kakoli, and yes, ma'am has asked me to take the session on criminal laws because, of course, I have a great interest in this subject. And in general, criminal laws are very interesting. So, I have taken very core and base जहाँ से criminal proceedings start. That is FIR, complaint, and your investigation stage ka role of prosecution and defense. So we will be using slides and all key because we are educators, of course. We love to portray and in a creative manner any text or any content that we teach. So of course we have slides for you all, which will help you understand the theory nicely, and then in the end, Anirudh will explain the investigation wala part thoda, and followed by the FIR filing by visiting the websites. Ki how you can file FIR, how you can search FIR, and everything. So before delving into the practical aspects, of course, theory is very important. Ki knowledge hi nahi hai, then you can't apply it as well. So we'll be dealing everything because I know there are a lot of law students out here. There are advocates as well. So for law students also, it's very important that you should have basic knowledge of BNSS, FIR provisions, and everything that's important out there. Okay, so I'll be sharing my screen also, and I'll be trying to draw a diagram and explain these stages as easy way as possible. Okay, so shall I share the screen, sir? Shall I go with it?
Yes, ma'am, please.
Okay, sure. Okay. So if you have any queries, you can just drop it in the comment box. One of us will definitely address it, and in the end, we'll definitely have a session of doubt clearing and so. Just a second. Okay. Are the slides visible?
Yes, ma'am, it's perfectly visible.
Okay, fine. So basically what I'll be dealing is the FIR and complaint complaint wala part, Anirudh with the investigation. So before I go through the sections and all, let me give you a brief about the investigation ka stage. We'll not delve into it very deep because of course another session is scheduled for you all on that. But FIR samajhne ke liye you need to understand the stages. Okay, briefly. So I'll be using this to explain. See, if for example there is a crime that has taken place, you can consider murder or any serious offense that has taken place. So see, there are two types of offenses, mainly cognizable and non-cognizable, which every law student has idea of. Cognizable offenses may be a police officer does not require a warrant. Okay, I'll show you how warrant is also, how it looks like as well. So arrest warrant jo hai, police does not need it. Okay, because if they will waste their time seeking warrant from the magistrate, the offender can run away. So to avoid that scenario, what they can do is they can go and directly arrest the accused when any crime has occurred. Okay, so first thing, if we divide this into two phases, so crime ke andar there is first of all police, okay, who plays a very important role whenever a crime takes place anywhere, and then we have magistrates. Fine. Now, when I say police, so see, like I said, there are two major classifications of offenses. So police ke andar hi we can divide it into non-cognizable and cognizable. So when I say non-cognizable are offenses which are not very serious in nature, जैसे defamation हो गया, okay, then simple hurt हो गया. So all these kind are very less serious kind of offenses for which FIR is not filed. So FIR is a first information report that is filed only in cases of cognizable offenses. So here, whenever a cognizable offense takes place, here comes the FIR. और अभी BNSS ने section 173 में it has included your FIR, okay, entirely, which we'll discuss obviously. And when we say non-cognizable, so if you have witnessed any crime or if you are a victim or anything, then you can go to the police and you can file for the crime. Okay, if it's a non-cognizable offense, so FIR file nahi hota hai. We have in that case the non-cognizable register. There is a non-cognizable register in which the police notes down any non-cognizable offense, and so this is the basic classification. Okay, now if police refuses to lodge your FIR in case of any cognizable offense, yeah, non-cognizable offense ke case mein, you can also go to magistrate directly of your area. Okay, you have district courts in your area, you can go to a magistrate, you can directly file a complaint to a magistrate, okay, in case of non-cognizable offense. Or agar police has refused to file for cognizable, again magistrate will come to rescue. Okay, so this is the role of magistrate, they will always be there to help you out. Fine. If the police refuses, so यहाँ पे you go to the magistrate and then you file a complaint. So whenever we go to a magistrate, we don't say FIR. We always say we have filed a complaint with the magistrate. ठीक है? So when we say this, now complaint can be again of two types. If the police has refused to file your FIR, then you can go to the magistrate for this cognizable offense or for non-cognizable offense. So what the magistrate will do, magistrate will direct the police. Okay, ये magistrate का role है कि magistrate will direct the police कि go and lodge FIR because it is a cognizable offense. You cannot refuse it. Always remember your rights. No police officer can refuse. Okay, filing FIR. Okay, so magistrate will order the police officer कि cognizable offense हुआ है. We will use his judicial mind कि okay, this is murder या rape जैसा serious offense है. So you have to file the FIR. So here order दे दिया जाता है to police कि go and investigate. Fine. So how this is done? So ये जो order देते हैं, the order which is given here, it is given via report which is sent to the magistrate. Okay, report is sent to the magistrate seeking. For example, cognizable offense में FIR file हो गया, fine. अब non-cognizable में what happens? Non-cognizable offense में here again the magistrate will say कि if the police wants to investigate for non-cognizable offense, तो हमेशा police will require permission from magistrate. Cognizable में you don't require permission, you don't require arrest warrant, but in non-cognizable police will always require permission. So how they get it? They have to file a report to the magistrate. Okay, कौन सा report? It is basically an application which police writes to the magistrate, in which they will write the nature of the offense. Okay, what sections they are invoking. For example, if the case is of defamation is non-cognizable, it is less serious in nature. ये पूरा classification ना of cognizable, non-cognizable, you will find it under schedule of your BNSS. Okay, schedule 1 of BNSS. Everything is written over there in the table. You can go and check it out as well. Fine. So here the police officer will go and file this application कि you permit us, then we will start the investigation. ये simple procedure होता है non-cognizable and cognizable offenses. Fine. Now after this, what will happen? If for example arrest is made, okay, अब investigation is done here, investigation का permission मिल गया in case of non-cognizable offense, and in case of cognizable offenses directly police has started the investigation. So if the accused is found, then arrest will be made. Okay, now arrest is made. So whenever an arrest is made, so it's very important to remember कि within 24 hours he needs to be presented before the magistrates. Okay, so within 24 hours he needs to be presented, and this 24 hours के span में the police will keep on investigating. And so if after this यहाँ तक होता है आपका this is basically your police custody. Police custody is your lockup. Fine, this is police custody. After this, when the accused reaches the magistrate, now from here comes the court car. That is, now after this magistrate के पास the accused is presented. Okay, within 24 hours. So now magistrate will decide what needs to be done. If the police investigation is not completed within 24 hours, then obviously the police will ask to give us some more time. So how much time? Usually serious offenses में it is 60 days. That is non-serious offenses में 60 days, and serious offenses में it is 90 days. Maximum time a police can get for investigation, okay, for any offense. Okay, अब ये 60 से 90 days के period में, according to BNSS, this is the major change brought by the BNSS, कि police can do one thing. This 60 and 90 days is your judicial custody. From police custody, now the accused has been sent to the judicial custody. Okay, this is the transition. That is jail, central jail में भेज दिया जाता है. So यहाँ पे they are spending, so the 60-90 days में the police will have to complete the investigation. So if the police wants, they can take out 15 days का time out of the 60 or 90 days, and they can take the accused back from jail to lockup for investigation. That is, क्या हुआ अपना जो ये hierarchy है, it becomes 24 hours, then your 15 days, then your 60 days, and then your 90 days. So what BNSS has done, 15 days पहले ये था sequence. Now this 15 days can be invoked by the police officers within any time period between 60 and 90 days. Okay, for less serious it is 60, for more serious it is 90 days, and so Okay, so this is known as remand. Okay, custody is the judicial custody and all is your remand wala phase. Fine. So from here only warrant or summons case ka distinguishment is there done. That is, ये जो 60-90 days का जो investigation time है, this is usually given in warrant cases. Now warrant cases are basically where the offense is punishable with imprisonment more than 2 years or life imprisonment or death penalty. Okay, that is known as your warrant case. So warrant cases mein this is basically the setup. And in case of summons cases, which is less than 2 years ka minor offenses, usually the accused is kept for a period of 6 months. Okay, 60-90 wala itna, these kind of chaotic concepts are not invoked there. 6 months ke liye they are taken. This is the major investigation procedure that you have to keep in mind. Okay, that crime takes place, police, magistrate, you have two options. Non-cognizable, cognizable, keep in mind. Okay, distinguishment is given in your BNSS ka schedule 1. Fine. So when it is non-cognizable, always remember police makes the entry in the non-cognizable register. When it is cognizable offense, always FIR is filed. And if the police refuses to file FIR, okay, not in cognizable offenses, you can always go to magistrate and file a complaint. Okay, or for non-cognizable also, you can go to the magistrate and file a complaint for that. Okay, this is the basic stage here. So now, after understanding the stages, now this section will be clear to you. See, everything is written here. What I liked about BNSS after the coming of the new criminal laws is कि now they have specified expressly कि their zero FIR is allowed, e-FIR is allowed. Now zero FIR is very important. पहले भी this was allowed, but expressly it was not written in CrPC. Now what it has done is irrespective of the area, this word has been mentioned in your BEAR Act. So whenever a judge, a magistrate interprets this is how a judicial mind is applied. Okay, so or a legislature or parliament has brought this particular provision expressly mentioning कि if a crime has committed, irrespective of the area, जो भी nearby police station है, you can go and report the crime, you can go and file FIR, and police cannot deny it at any cost. Whatever jurisdiction में जो transfer करना, whenever the police will need to transfer the case or this your FIR to the respective jurisdiction, that can be done later. But they cannot refuse you, because if this happens a lot of time, for example, if I am in Raipur and this particular area and I have witnessed some crime, okay, and my friend has told me that this crime has been committed in, for example, in Mumbai. So now I can't go to Mumbai and file for that and this and that. So what I can do is कि यहाँ पे I can register an FIR and I can ask the police कि you just registered it. The police station will send it to the respective jurisdiction later on. But at least the crime will be reported. So zero FIR is very important, and now it has been mentioned. So okay, this is your clause 1. Then your this particular thing orally you can give. Now is that key after this particular thing. Okay, so remember that whenever you are going to a police station, you are dictating whatever crime you have seen. Police will write it down. Okay, everything will be written. Okay, whatever oral dictation you are giving, and then it will be read to you. This is exclusively mentioned in the section that whatever they are writing, whatever you are saying, the police will read it out to you. Okay, to the informant. The informant can be anyone, either you or any other victim or anyone who has witnessed or heard of the crime, and then it can and then a free copy of that FIR will also be given to you if you are filing it offline by visiting the police station. Okay, but now again BNSS ne another thing which it has done great is that it has again included e-FIRs expressly in its provision. Okay, under section 154 of CrPC these words were not used, but now there are. Okay, these words. So when I say e-FIR, as you say, we'll also show you the website. Anirudh will show you the websites also, how you can view and search FIR, how e-FIR will be filed. So e-FIR can be filed where 3 days का एक time period होता है कि within 3 days the person who has lodged FIR will be called for signing it. Okay, and then the process will begin. The process which I explained you via diagrams and so. Okay, so this is the e-FIR provision. Now there are proviso as well. This proviso was there even in CrPC as well. Ki if there is any offenses against women is committed, or if for example if there is any victim, okay, any victim who is for example if there is a victim who has like with whom a rape has occurred, for example, it's a very serious offense. So obviously in that particular case presence of a woman officer is always necessary. So if a woman who is a victim is uncomfortable telling the details of the crime and anything, there will always be a woman officer. And these are all the sections under BNS, जो आपका IPC था, okay, that deals with the offenses against women वाला part. ठीक है. Now जो second proviso है, okay, maybe the section will look very heavy, but it's very easy sections. Okay, it clearly mentions everything. Just like we said, कि for women-related offenses, you will have women officers. So for any disabled person, physically disabled person या कोई है who cannot come to the police station and cannot lodge FIR, and so of course police can visit them at their residence. Okay, and everything will be videographed. Okay, whatever recording you are doing, it will be videographed, and then the magistrate can come and also record it, because the person is physically challenged or disabled, so they can't visit the court or the police station in that case. Okay, so this is what it's given over here. And a very important provision brought under this is your preliminary inquiry. Now, basically, Lalita Kumarika, there was this case, a very landmark case in CrPC, Lalita Kumari's case, which talked about the preliminary inquiry. But now BNSS has exclusively mentioned this in its section, कि when it is taken. For example, if I am a police officer and I'm confused कि an offense which has taken place is cognizable or non-cognizable. Okay, maybe I'm not aware of I'm not getting the nature of the offense. So I will take permission, okay, from an officer who will not be below the rank of Deputy Superintendent of Police. Fine. So DSP से I'll take permission, prior permission, कि I need to do a preliminary inquiry of the crime which is being reported, because I'm confused about its nature. So if the police officer wants to know whether this offense is cognizable or not, because FIR is filed only in cognizable offense, they can always have this option of preliminary inquiry, जो कि needs to be done within 14 days. Okay, and this is also is given in your section only. Okay. And usually preliminary inquiry is taken only in offenses that are punishable with imprisonment more than 3 and less than 7 years. Ye bhi clearly it's mentioned over here. So only in these kind of offenses preliminary inquiry will be conducted, because if there is an offense for which the punishment is more than 7 years, जैसे murder, rape, 10 साल का, attempt to rape, 10 years का punishment, these are the evidently cognizable offenses. So why would the police officers will have any doubt regarding its nature? The doubt arises only with respect to these kind of offenses जिसका punishment ranges between 3 to 7 years. Okay, that's why. And less than 3 years though are the simple non-serious wale offenses, like I told you, simple hurt and so like that. Okay, or defamation and all. So this is the limit. So this is also very important provision here. So for this it can be done. Okay, so this is basically your section. The whole section revolves around this. Fine. So okay, I'll just take a halt here. Okay, if anybody wants to ask anything, whether any doubt or whether everything is clear or not, then I'll move on to the slides. Any doubts that any one of you have? Or do you think the amendments of the new criminal laws can solve the issue of under trial prisoners? Under trial prisoners, see, BNSS mein na zyadatar changes have not been brought. Okay, this is one of the loopholes of the new criminal laws, ki major changes are brought in actually it is brought in BNS thoda bahut, but BNSS mein they have unnecessarily also there are a lot of changes that have been brought, so that I agree. So under trial prisoners ka, I don't think so that much problem will be resolved, but yes, because of specifications are there ki trial needs to be finished within this time period, and also that will help out a little bit. Okay, then see, and with the cognizable, non-cognizable ka distinguishment is given in your BNSS schedule only. In schedule, it's clearly written which offense is cognizable, which is non-cognizable. So you can take help of that to identify the nature of the offense. Fine. And anything else? e-FIR will get registered in the state's portal itself. Like har ek state ke jo police hai, they have their respective websites. Like for Chhattisgarh, we have a Chhattisgarh police wala website. Delhi police has their own website where you can go and file FIR, view FIR. Anirudh will show that as well. We have some websites reserved with us that we can help you out with. Rishabh, 15, 16, 90 is basically if a police officer could not finish investigation within 24 hours. So they will have time of 15 days to finish the investigation. then 60 days, and then 90 days. 60 for less serious, 90 for more serious offenses. Okay, so now police can invoke this 15 days ka period between 60 to 90 days mein. So 60 and 90 days are your judicial custody, where the magistrate keeps the accused in jail. Okay, and your 15 days and 24 hours is basically your police custody, which is your lockup. Okay, so ye different, this actually helps you distinguish between police and judicial custody. Okay, anytime, Ashok, anytime. The BNSS has introduced this provision that 15 days can be invoked by police at any time within 60 or 90 days. Actually, this is also been criticized because some of the renowned advocates have also criticized this provision, saying that this gives a discretionary power to the police officer to take the accused anytime within this day and put him in the lockup. Okay, so it can be taken anytime. Bail का ऐसा है कि if the police officers does not finish the investigation, fails to finish the investigation and collect evidence within 90 days max, या 60 days max, default bail is granted to the accused by the magistrate. Okay, default bail आता है. Preliminary inquiry, Anuya, is basically about when a police officer is confused regarding the nature of the offense, whether it's cognizable or non-cognizable, when the crime ranges between 3 to 7 years ka punishment. Okay, because more than 7 is definitely cognizable. Fine. So there they can take permission of DSP and they can do a preliminary inquiry in that case. Fine. Okay. Time limit presented in front of magistrate is 24 hours, and then it goes till 90 days max, like I told you. Okay, so now coming at the what is a FIR wala stage, back to this. So see, FIR, I told you, it's a first information report and it's a written complaint given to a police about a cognizable offense. So cognizable offenses are very serious offenses, and iska bifurcation is given in your BNSS ka schedule. Okay, in your BNSS schedule. So you can go and check it out. And murder, rape, kidnapping, theft and all are your cognizable offenses. Fine. So remember the section. As a law student, as a lawyer, you should know the basic section of FIR, which is 173. Previously, it was 154. Just learn this by heart, which is the section of FIR. Okay. And complaint is given under 233 of BNSS. Pehle 200 mein tha, but now it's under 233. Okay, and so now, why is FIR important? It starts the criminal process, which means police cannot begin investigation in a cognizable case without registering an FIR. Every time FIR has to be lodged whenever there's a cognizable offense, it protects the victim because the complaint becomes part of the official record. Okay, so police makes this entry to the case diary as well. Police maintains a complete case diary where they record everything, whatever they are doing in investigation, whatever they are writing, wherever they're going, everything is given in the case diary. And from that case diary only they take help and they prepare the charge sheet. Okay, so it's very important to know. Then it forms the base of the case. FIR forms the base of the case, and it ensures accountability. Okay. Now, can anyone tell me, is FIR a substantial evidence? You can give me the answer in yes or no. I wanted to know whether you're understanding or okay. Yes, it is never considered as a substantial evidence. No, Jayashri, it's never a substantial evidence. FIR झूठा भी तो हो सकता है. What's the guarantee कि सामने वाला सही में they are stating all the correct facts? FIR is just a copy which helps the police to file the charge sheet, and then it never forms the substantial evidence before the magistrate. Investigation जो charge sheet होती है उसके मदद से the magistrate frames charges, मतलब basically frames charges, tries to understand the case, applies judicial mind and everything. Okay. Yes, they have to read the FIR to the complainant. That's the right. The police will have to read it. Whatever you are making them write, they will read it to you. Okay. Now, it ensures accountability. Of course, police actions are recorded. And remember, whenever you are going to file FIR, remember always that police will have to make an entry in the case diary. Fine. So you can ask them that whether you have made entry in the case diary or not. You can definitely ask the police officer whenever you're going to file it. Okay, for any reasons. Now, what information is included in an FIR? See, date and time रहता है, place of offense is there, what exactly happened is there, names of accused is there, witnesses is there, details of the complainant. Complainant can be anyone. It can be a third person also. It can be a victim also. Means whosoever has witnessed a crime. Okay, any evidence available, everything will be written over there. Okay. And when should you file an FIR? When a cognizable offense is committed, you have seen the crime, you know about the crime, or you suspect that a serious offense has been committed. You'll obviously go and report it to the police. Okay, I'll show you some original copies as well. See, this is as per CrPC. Now they have what they have done is कि now it comes under BNSS का 173. Okay, but थोड़ा इस type का FIR का format can differ a little bit as well. So see, everything is an occurrence of offense, day and time, date वगैरह, general diary, entry notes and all which police enters. Okay, case diary में ये सारी चीजें they will put up, and then we have place of occurrence, address, complainant's information. If you are a person who have seen a crime being happened somewhere, and so you can definitely give your details of known, suspected, unknown, accused with full particulars. Like if you are a complainant, for example, and you have an idea ki who can be the accused, you can tell it, you can definitely convey this to police officer. Yeah, I think this person can be the accused. Okay, with full particulars about that person. Then if you have not reported it at an early stage and you are reporting it after 2 to 3 days or 4 days later, so you will state the reason of your delay. Why did you delay? Okay. Then particulars of any property stolen. If any property has been stolen, you can go and lodge FIR and so. Okay, total value of the properties. Everything is given in this FIR only. Simple. Now, coming back at this again. Fine. Just a second. So here, how to file an FIR, offline process. This also I told you. Visit the police station, nearest police station, irrespective of the area. Okay, here comes your Zero FIR ka. You can go and visit any place. Okay, then give complete details. Explain clearly. It's very important whenever you're lodging FIR. Don't sugarcoat. Say everything that you know. Okay, like what happened, when it happened, where it happened, who was involved. If you know, then you can state this. Okay, it's not necessary you will know every time. Police writes the FIR, okay, and then it must match what you stated. Whatever you are saying, the police will read it out to you. Why this provision is inserted? So that the police officer cannot additionally include any information by mistake. Okay, that you have not stated only. Okay, so to verify that, this reading wala provision is inserted. Okay, shuru se. Then read and sign it. Then we have get a free copy. You'll always get a free copy or a photocopy of the FIR that you have filed. Okay. And after this, after FIR investigation stages, if the person is a rape victim, of course, medical examination of rape victim is done. Every such thing is inserted in the case diary only by the police, and then charge sheet is the final stage of an investigation. Okay, when entire investigation is over, charge sheet means challan. Okay, in Hindi, challan is filed. Fine, and charge sheet can be both positive and negative. Positive when you have found the evidence. Negative when you have not found the evidence. So if you have found the evidence, well and good, trial will take place. Not found the evidence, so matlab you don't have any evidence against the accused, investigation khatam bhi nahi ho paya, bail will be granted. Okay, default bail and so will be granted. Okay, now, so this is final report is a charge sheet only. Now, can an FIR be cancelled? See, in a lot of times we think it can be cancelled, but you cannot withdraw FIR that easily. Once it's filed, it's filed. But what can be done is, High Court has the power to quash an FIR. You can go to an advocate, practicing advocate, and of course you can take their help. They'll file for quashing the FIR in the High Court directly. Okay. And when can an FIR be cancelled? If the FIR is false, usually the accused person does this. Like if I am the accused and somebody has filed FIR against me, I want to quash it. So of course I'll take help of my advocate and I'll go and just file it. Okay. And if the FIR is false, if it is malicious, if no offense is made out, then in that case also, and the dispute has been legally settled outside only, then you can go and quash it. Okay. Now, can an FIR be withdrawn? Normally, once filed, it cannot be withdrawn. It's a general rule. However, compoundable offenses where settlement can be done easily, like some matrimonial dispute, then in that particular case, it can. But usually, you can't withdraw it. It can be cancelled only by the High Court quashing order. That only can be done. Fine. And you have to state the reasons, of course. It's not that you have just filed the FIR for no reasons. So it can't be like that. Okay. And what if police refuse? Now, this is very important and everybody should know this. If a police refuses to file FIR, you always have this option. You can write a letter to the superintendent of police. You can post it directly to his official address. Okay, you can send a written complaint. Okay. So SP will help. SP will then direct the police officers to do so. Or you can do one thing like I told you, ki not just the SP, you can approach the magistrate also, ki the police is not investigating. Okay, you can file a application to the magistrate through your advocate ki, please order the police officers. Magistrate will do one thing, ki they will order the police go and lodge FIR. You'll have to investigate because it's a cognizable offense. Okay. Or you can file a writ petition in High Court. Writ petition is always filed in High Court or Supreme Court only. District Court you can never file writs. It's basically filed when there is a violation of your fundamental rights. High Court में not just fundamental rights, even if your different legal right is violated, like any matrimonial dispute हो गया कुछ हो गया, then only you can file that writ. So High Court का writ jurisdiction is wider compared to Supreme Courts. Okay, so these three approach can be made. Fine. Now, what is a complaint? This also I have given you a brief about this. A complaint is when a person goes directly to a magistrate and informs them about an offense. Okay. Like if the police officer is not filing FIR or if non-cognizable offenses, you can directly go to the magistrate and file the complaint. Okay. This is a section basically, and it is made to a magistrate, usually not to a police. Complaint word ही magistrate के साथ we use. Fine. And it does not include a police report. Okay, nothing related to police report or FIR. It is completely related to magistrate. It is given to magistrate usually for non-cognizable offenses. And when the police refuses to file FIR, then also you can go and file a complaint. Okay, so court decides what to do next. Now, next we have what if when is a complaint filed? So again, when police refuse to file FIR, the offense is in non-cognizable register to the police or to the magistrate. The person wants direct court action. So here, obviously, police officer will always require permission from magistrate to conduct investigation. Okay. Now, private disputes like defamation, check bounce, and all. Fine. Now coming at the procedure in case of, see, very basic procedure this is in case of non-cognizable offense, ki how can you file a direct complaint to magistrate? So the person files the written complaint to a magistrate where he will describe what has happened, when and where, who committed the offense, for the basic details that will be written over there. Then the magistrate will examine the complainant before ordering police officer to register FIR or to investigate and anything. The magistrate will use his judicial mind. Examine, may also examine witnesses if needed, and so then he will apply his judicial mind. Either he will dismiss the complaint in what grounds? If he thinks कि ये तो offense बनता ही नहीं है, there is no non-cognizable offense here, or there is no point taking this further, so we can just dismiss it. Okay, and if issue summons to accuse, then he will issue summons to accuse or order police investigation if the police has refused to file FIR and so. Okay, these are very basic things. Now, how to file? Drafted, submit, and magistrate examines, decides next step, and it's done with. Okay, so what happens after complaint? Summons are issued, case proceeds as a regular criminal case, evidence is required, recorded and required. Okay, and trial will begin. Okay, so the entire diagram which I showed you, it's pretty much that only. Fine. And remember, sufficient ground has to be there. Fine. Now, so this was FIR and complaint in total. Anybody has any other doubt regarding FIR and complaint? Then Anirudh will continue with the investigation. Okay, role of prosecution wala part. So yes, Gautam, for non-cognizable offenses, one should directly approach the magistrate. And you can also go to the police officer, where the police officer will write it in the non-cognizable register. But the police will have to take permission from the magistrate before starting the investigation in case of non-cognizable offense. Okay? So you are right, of course. And if the FIR is registered has included an error, whether intentionally. See, FIR, whatever FIR you have registered, it is not necessary that FIR mein jo bhi bola hai, it will be correct. So it is never a substantial evidence. So it can be incorrect also. So we will not verify that because investigation police is doing to verify that only. So of course, wrong information can be given in FIR. That's why magistrates never consider it as an evidence. Okay. Now, when we file private complaint, If the police, if like for example, if you have filed a private complaint regarding this cognizable offense, for example, magistrate will tell the police officer, go and investigate, file FIR, let them file FIR, go and investigate, and then complaint ka nature will be finished. Then the investigation will continue and trial will begin. If 90 days, 60 days can, the investigation is done. Okay, it all depends upon the nature of cognizable, yeah, depends upon the nature of offense. Okay, and then the entire diagram and hierarchy will follow. It's just that. e-FIRs, again, like I said, कि FIR का evidentiary value is not there. It's not a substantial evidence. So that's why 65A and 65B is basically certificate to attach करते हैं हम when it comes to recording of any digital evidences, and so it has nothing to do with FIR वाला part. Those are the value. Those are the actual primary evidences or that we take into consideration. FIR can be wrong as well. So it will never have a good evidentiary value or something in the court of law. Okay, so I think I pretty much addressed this. Charge sheet is also not no. FIR is never given that much important. Charge sheet is basically police gives to the magistrate, from where magistrate will start the trial ka stage. Framing of charges hoga, then appearance of parties and all. Pura trial stage will begin. Okay, so none of these has an evidentiary value that much in the court of law. None of these. Fine. While filing for an FIR, does one have to present evidences? It's not necessary. If you know about the evidence, you can tell the police. They will write it down in the FIR. It's not necessary because you are the complainant. You will not have all the idea of, you will not have every information regarding that offense. Okay. Yes, Yash, we'll definitely share the slide link with Jayant sir, and they can definitely send you the slides. Okay, the slide is for everyone. We'll definitely share with all of you. You cannot add anything to the charge sheet. Charge sheet is the final stage which the police officer submits in the court of law. We, as an complainant, accused, victim, has no role in the charge sheet. We cannot edit it at any cost. Charge sheet is the final stage of investigation. Now, whatever you will have to prove, you will prove it in the court of law. Okay. Then, if it is not completed within 60 or 90 days, Shreya, then the accused will get a default bail. Bail is given. Okay. See, first of all, to Santosh, you need to check whether theft is a cognizable offense or not. And yes, theft is a cognizable offense. If they refuse to file it, you can go to the superintendent, you can file a letter to him, and he will direct it. Or you can go to the magistrate and file a complaint against the police officer, and so on. They will direct the police officer to lodge FIR for you. Okay. Bhavna, photo of drafting and all, we will show you. We will show you. And these PDFs are easily available on internet as well. And draft switches, change hota hai, FIR ka. Okay. You can easily get it anywhere. If the punishment is less than 2 years, Renisha, then in that case, 6 months ke liye the person will be sent in the custody. That is summons case ho jata hai wo. So itna serious investigation is not needed. Fine. So okay, so I have addressed all of your doubts. Now Anirudh will take over with the role of prosecution and defense in investigation, followed by the website searches. So I hope I was able to clear your doubts. Now I'm just Anirudh will take over now. Then we'll again address your queries and so. Okay.
Thank you, Kakoli. Thank you so much. I hope that wasn't too much heavy on the theory, right? Can I get quick reaction on this? If you guys are awake, if you guys are with me.
I know it was heavy on theory, but yeah, it's important before you understand the practical part.
I can see lots of yes. Okay. It's good. It's good. Thank you, Priyanka. Thank you, Swapnil. Thank you, Mohan. Okay, all right. So before I start, am I clearly audible to you? Am I clearly visible to you? Can I get quick reaction on this? Because I have joined from a different device.
Yes, sir. Yes, sir.
Now I'm sharing my screen. Is my screen visible? Kakoli, it's visible?
Yes, visible. It is perfectly visible.
Perfect. ऐसा रहा. So this is going to be very interesting segment. In this segment, we will briefly discuss about who are the parties in criminal proceeding, featuring very famous movie of Jolly LLB 3. Then we will discuss about the role of the prosecution and the defense at the investigation stage. Then we will see live demo of how we can file e-FIR and how to search already registered FIR. You'll get live demo of this. Moving on to the next slide. So investigation. If we say investigation, as Kakoli pointed out, that investigation started once the cognizable offense is reported, right? And it continues until the police finalize the investigation and submit the charge sheet or the final report under section 193 of BNSS. Right, so this is the investigation stage. Investigation is primarily done by the police, but we'll see how the defense counsel and the prosecution plays important role, in fact, during this investigation stage. So why this investigation period is important? Because during this period, the evidence are collected, the suspects are identified and questioned, arrest can be made. Then police record a statement of evidence, witnesses and victim. Police also conduct searches, and this is all form the basis for the prosecution. Now, coming to who is who in the criminal proceedings, may I know, have you guys watched Jolly LLB 3 yet? Can I get quick reaction on this? Is it yes, no? I can see yes, okay. अगर तुम लोगों में से किसी ने जॉली LLB 3 नहीं देखी है, टुडे इज सैटरडे, tomorrow is Sunday, go and watch this movie. It's a recommendation from my end. Okay, so Jolly LLB 3 was basically, primarily, it was a civil case of land dispute, but for the sake of understanding who are the parties in the criminal proceedings, I have taken this example. So first is this Amma, who is the victim. Some affluent builder took her land illegally. So the victim is a person who suffered the harm. Second party is the state. Now this is the important party because state represents the victim. So see, in the criminal law, the victim doesn't fight the case alone, because whenever a crime is happened, it is considered as an offense against the society and not society as a whole, and not just against the victim. तो जब भी क्रिमिनल ऑफेंस होता है, तो वहां पे विक्टिम के साथ स्टेट भी उसी के साथ फाइट करता है उस केस में. दैट इज व्हाई जब whenever you see civil case, there is a person versus person, that is A versus B. But in a criminal case, if you see, there is a state versus person. Now this person is the accused one. एंड ये वन ऑफ द मेजर इंपॉर्टेंट डिफरेंशिएशन है बिटवीन सिविल केस एंड क्रिमिनल केस, जहां पे आप केस टाइटल को देख के बता सकते हो वेदर इट्स अ सिविल केस और क्रिमिनल केस. एम आई क्लियर टू यू गाइज? Perfect. Now, who represent the state or the government? बेसिकली हम उन लोगों को बोलते हैं सरकारी वकील, जो कि होते हैं पब्लिक प्रोसिक्यूटर्स एंड असिस्टेंट पब्लिक प्रोसिक्यूटर्स. नाउ सी, पब्लिक प्रोसिक्यूटर्स जनरली प्रैक्टिस इन सेशन कोर्ट्स एंड असिस्टेंट पब्लिक प्रोसिक्यूटर्स practice in magistrate court. Now to become public prosecutor, that is PP or APP, you need to write an exam. हर स्टेट का एक अपना एग्जाम होता है इसके लिए, फॉर विच यू हैव 7 year of practice. तो ये चीज आपको देखनी पड़ेगी अपने स्टेट के अकॉर्डिंग कि हाउ यू कैन बिकम अ पब्लिक प्रोसिक्यूटर फॉर दैट पर्टिकुलर स्टेट. सो पब्लिक प्रोसिक्यूटर इज बेसिकली सरकारी वकील, एंड दे कंडक्ट ट्रायल. राइट। बहुत सी मूवीज में आपने देखा होगा कि इफ अ क्रिमिनल ऑफेंस इज हैपेंड, फॉर एन एग्जांपल, अगर किसी मूवी में मर्डर हुआ है तो जो विक्टिम है डायरेक्टली एक वकील के पास जाते हैं, बट रियल लाइफ में ऐसा नहीं होता है। अगर कोई जो मर्डर का विक्टिम, आई मीन जो मर्डर हुआ है उसके रिलेटिव डायरेक्टली किसी प्राइवेट एडवोकेट के पास नहीं जाते, उन्हें एक स्टेट के एंड से पब्लिक प्रोसिक्यूटर असाइन होता है। अब इफ दे वांट कि उन्हें एक प्राइवेट एडवोकेट चाहिए, तो वो प्राइवेट एडवोकेट ले सकते हैं, बट जो केस है वो सिर्फ पब्लिक प्रोसिक्यूटर ही कोर्ट में रिप्रेजेंट करेगा। Moving on to the third party in the criminal proceeding is the accused. Accused is the person against whom the allegations are made, right? Accused, मुझे लगता है this is very understood term, but some of the pointers, important pointers that we need to understand here, that the accused is presumed innocent until he is proven guilty. First thing. Secondly, he has some constitutional protection under Article 20, which states the protection in respect of conviction of offense for offense, and Article 21, which talks about life and personal liberty. Also, he has right to have a counsel. And who would be that counsel? That would be the defense counsel. That is our fourth party in the criminal proceeding. He basically represent the accused. See, defense counsel का काम सिर्फ यही नहीं होता है कि वो innocence prove करे, but they are also need to create reasonable doubt in front of court. So these are the four are the major parties in the criminal proceeding. Of course, there are other parties like witnesses, then magistrate, the court, but these are the major parties. Moving on to the role of the prosecution and investigation stage. See, investigation जो होता है, that is primarily domain of the police, not the court, not the prosecutor, not the defense counsel. But public prosecutor हो गया या फिर state counsel हो गया, they play very significant advisory role during this investigation stage. I show you how. So number one is they provide legal advice to police. In complex cases, police often consult public prosecution regarding framing of charges, if the correct sections are applicable or not, then whether the evidence is sufficient or not. They also help in drafting charge sheet. So number one, they provide legal advice to police officers. Second is they appear in remand and bail proceedings. So see, during the investigation process, when accused is produced before the magistrate, so the police can seek either custody or the judicial remand. Or second option for the accused is they can file bail application. Now here, what the public prosecutor can do is they can argue if the custody is necessary from the police and to interrogate the accused, or the public prosecution oppose or the respond to the bail application. Public prosecutor also seek to search in help in seeking search warrant and production orders. Like if investigation officer wants to access digital servers or call details, then the police may approach magistrate. Now, what here the public prosecutor will do? He will help investigation officer to prepare affidavit. Like he can help in vet legal grounds. He ensures that requests are legally sustainable. He checks all the constitutional compliances, either whether the constitution basically check the constitutional compliances and refine the scope of search request. So what is the process for behind this? So investigation officer prepares affidavit which contains nature of offense, why the documents are necessary, why voluntary production may not be possible, and this is why we need custody of the accused. Now the public prosecutor reviews all these document and affidavit and vets the legal reasoning. Then the application filed before the magistrate, and then the magistrate evaluates the affidavit. If the magistrate is satisfied, then the search warrant is issued against the accused. Now, see, if the search warrant is vague, not based on the proper affidavit, and lack the judicial justification, then the defense at the later stage, right, when the trial starts, the defense may later argue that the search was illegal. Then there is a violation of procedural safeguard, and which weakens the evidentiary value which was gathered during the investigation process. Then the last point is public prosecutor helps in scrutiny before filing the charge sheet. So in serious cases like murder or offense related NDPS Act, POCSO, prosecutor reviews whether the mandatory section required, whether forensic report was attached or not, whether a conventional statement legally admissible or not. For example, this is a very interesting example, that if the confession is made to a police officer, public prosecutor will advise that no, this is not the admissible under Evidence Act, which is now Bharatiya Sakshya Adhiniyam, and with that is why this the entire role of public prosecutor prevents prosecution prevents a weak prosecution at trial. So we have seen that the investigation is police primary domain. However, prosecution helps in legal oversight and court facing support. Coming to the what is the role of defense at the investigation stage, अब हम accused के advocate का role देखेंगे during the investigation stage. So the defense does not conduct like public prosecution. Defense also doesn't conduct formal investigation like police, but it performs constitutional protective functions like defensive and rights oriented things for the accused. So the first role is protecting accused during interrogation, right? Police call the accused for questioning, interrogation hota hai, and they ask accused that they majorly they ask everything about the offense, what has happened. So the defense lawyer here can advise that accused can refuse to answer incriminating questions like did you kill the victim or did you create the false invoice. He can advise that accused that you are not compelled to confess something, and he can assure that the silence is not guilty. What are the legal basis for protecting accused during interrogation? There is Article 20 of the Constitution, which talks about protection against self-incrimination. Then Article 21, Section 180, which talks about person is bound to answer question except those exposing him to criminal charges. And this is the incriminating questions which we have talked in the last slide. And all of these this is recognized in Nandini Saptapati case, in which court has said that accused has a right to remain silent regarding incriminatory questions. Coming to the second point, so the defense lawyer can challenge illegal arrest or custody. So this is the one of the most strongest role that defense lawyer do during the investigation. See, if police arrest without proper grounds or following arrest memo procedure or informing reason to the accused, then the defense lawyer may file bail application, habeas corpus petition, which can only be filed in High Court, or challenge illegal remand of accused. Legal safeguard for these conditions are Article 22, which talks about right to be informed of grounds of arrest. Then we have section from the CrPC, like condition of arrest to be presented to accused, informing grounds of arrest, and production before magistrate of accused within 24 hours of arrest. Also, this is very landmark case, DK Basu, where the court has laid down mandatory arrest procedure like arrest memo informing relatives of the arrest of the accused, and medical examination to be done. This is a very landmark case regarding criminal law. Moving on to the third role of defense lawyer is bail application. So they can file bail application during investigation. See, most bail litigation happen at investigation stage. Defense can defense can either file anticipatory bail, which happens before the arrest, and the regular bail, which can be filed after the arrest. And the legal principle behind this is that the bail is the rule and the jail is the exception. For the bail application, defense argue that the acquisition is motivated by the person enmity. So these are the grounds which I have stated from the bail application, that generally advocates file in the court, that the also the matter is primarily civil case. For an example, it was a just breach of contract, but now it has been falsely converted into criminal complaint. Then the accused has no risk of flying away or tampering the evidence. Also, accused will cooperate with the investigation, and accused has no criminal background. So these are some of the grounds on which bail application is drafted. Fourth pointer is also defense lawyer can also file quashing of FIR. See, if FIR doesn't disclose any cognizable offense, if it primarily shows that this is non-cognizable offense, but still FIR has been registered, then the defense lawyer may approach the High Court. This is under section 482 of CrPC, right? Key grounds for the quashing of FIR would be that on prima facie case, it doesn't disclose cognizable offense. Then the party have amicably solved the dispute, particularly compoundable offense. Compoundable offense are for example, minor assaults or defamation or commercial matter. Then we have malicious intent. That, for example, the case was filed with motive of personal grudges. Then defense lawyer can file the quashing of FIR, stating that this FIR was filed on the ground of malicious intent. Then the case was civil dispute, but given the color of criminal case. Okay, so that was the role for a public prosecutor and defense counsel at the investigation stage. You guys are clear with that? Okay. All right, all right. So I'm continuing with the slide, and we will take your question at the end of the session, if it's all right. Okay, great. So now we will see how to file e-FIR. So this is going to be live demo. If you have your phone handy and you have joined this session from the system, I request every one of you to know just we will provide the link for this, and from your end, see if you are able to file e-FIR from your end. Okay, so e-FIR is basically FIR registered online through official state police website or mobile apps, right? Talking about what's the legal status for the e-FIR, it's normal as FIR. The only difference between e-FIR and the normal FIR is that the e-FIR is filed online, as the name suggests. It's or online FIR, and there is a no need to physically visit police station initially. See, remember the word initially. Why I put the word initially here, I'll explain in the later slide. Okay, if you have guys your open your Google on your phone and simply type online FIR with your state name. So, for example, I'll show you MP online. I'll show you MP ka police service portal. Is my screen visible to everyone here? So this is official police website of the Madhya Pradesh state, right? Here we'll go to the citizen services, and then you'll see e-FIR ka section here. Step 2 would be you have to log in this portal. You have to enter your name and the mobile number, and then they'll send you OTP, and you have to register from the OTP only. I have given the link of some of the police official police portal for e-FIR, and I am pasting this link in the chat box as well. Okay, once you log in from your mobile, you'll see this kind of message will pop up. सो बेसिकली यहाँ पे ये चीज आपको बताएगा कि आपकी ई-FIR की कैटेगरी क्या है, आपको किस चीज में FIR लॉन्च करवानी है, दैट इज थेफ्ट और व्हीकल थेफ्ट, इज देयर अ साइबर और ऑनलाइन offense which has happened to you, or the offense against women or children, and you select one of these, then the portal will show like this. यहाँ पे आपको आपका डिटेल्स फिल करना है, जहाँ पे आपका एड्रेस हो गया, देन देयर इज डिटेल फॉर द ऑफेंस ऑफेंस आपके बारे में और आपको चीजें बतानी है. सो बेसिकली ये ऑफेंस के बारे में सारी डिटेल्स यू हैव टू पुट इन दिस, and then you have filed the e-FIR. So yeah, it is easy. Are you guys able to do it from your end? If some of you guys trying to file FIR from your mobile? Mahi is asking, she doesn't have an account for this, so do I need to? Yes, you need to sign in first for filing e-FIR. Yeah. And so Santosh, entry and anticipatory bail is the option for this. Okay, so this was the procedure for how you file e-FIR. Moving moving on to what happens after you submit your e-FIR. So within 24 hours, police may contact you. SHO will assign to your case. Printouts may be taken of the details that you have filled in your e-FIR. Your signature may be required, and after all of this verification, FIR is formally accepted, and then the investigation process will begin. Now, do you remember I have said that in this slide? So in that slide, I have said that for if you file e-FIR, you don't need to go to police station initially, but as per the section 173 of BNS, if the victim doesn't appear, if the victim do not go to police station within 3 days, then the FIR will be rejected by the police station. So yes, if you file e-FIR, then only you have to go to police station. Moving on to how to search FIR using FIR number. So, this is very easy. So there is a two way. Either you can go to your government's police website of your particular state, or you can do this through e-code's website. Also, e-code website is an app. If you can download it on your phone, that is also convenient. So visit e-code website first. So this is how e-code website looks. Okay, then we'll go to services section. Here you can see the case status, right? And in the case status, this is the FIR number. So I'm clicking on the FIR number. Now I have to fill out basic details like state, district, code complex. So we are Chhattisgarh based. So I am selecting Chhattisgarh. District is Raipur. Code complex is Devbhog. And police station is Devbhog 1 I'm selecting. And for the FIR number, I'm putting random number for this. Here would be, let's say, 2020. Then I'll enter captcha, and this is the detail of the FIR that will show up on your screen as per our FIR number, right? And then comes the case detail, like the filing number, filing date. Also, what's the case status here? The case has been disposed of. Also, you can see advocates representing petitioner, advocates representing respondent. Also, under which section they have been tried. So it was under Indian Arms Act. Also, you can see copy of the judgment here as well. This is the copy of the judgment. So this is how you search for already registered FIR via e-code service website or application. Yes, so that was from my end. Now we can take up your queries.
Okay, so I have pretty much answered a lot of queries on chat itself. Okay, about all these e-FIR and everything. See, investigation and all जो जितने भी stages होते हैं, whenever you go and file private complaint to a magistrate or so, magistrates also have this power to do inquiry. Okay, before ordering the police to file FIR or so, and that is usually done between a period of 2 weeks and something. Okay, so magistrate also examines, will hear both the parties, then only they will go further. So most of the queries were around this only, as much as I have read. Okay, do you want to address the doubts on?
Santosh is asking, suppose I lodge an online FIR for cyber fraud, but later I realized some details were wrongly entered. How I can correct online FIR once it is registered? So, see, once you register the FIR, you have to go to police station, right? Or the police will contact you. In that stage, you can tell the police officer that I want to change this detail. Can you do it? And yeah, they can if it's a minor amendment or error.
And then, okay, any other doubts? So, charge sheet is filed by the police directly before the magistrate. Okay. they will file it, and it's not. Matlab, he has done the investigation. Investigation is done, and everything is done. It's completely police's department to look after it. Fine. Uh, You can get a counsel, yes, if you are unable to pay. There's obviously DALSA and a legal service authority where you can always seek help if you are not financially strong, or if you have a single mother or whatsoever be the reason. So in that particular case, you can always seek help of legal service authority. You can provide you public prosecutors or government counsel, of course, who can fight your case on your behalf and so. Fine. Zero FIR can be lodged for any crime because BRM doesn't specifically mention the type of crime. You can file FIR. Usually, zero FIR means you are lodging FIR only in another jurisdiction. So it is filed obviously for cognizable offences, which is automatically serious in nature. So yes. So once but the offence continues. Usually, where the offense is committed, that jurisdiction is taken by default. Usually, rest depends. But where the offense has actually occurred, okay, then in that, but for the first instance, then in that case, that state's police will be taking it up. Okay.
DB is asking, and does it also help for defense counsel? So see, uh, generally in practice, accused person hires their defense counsel only. The state doesn't, give counsel for to them to represent at the trial stage.
And public prosecutors and also government lawyers, like the state councils and all. That's the major difference. Key public prosecutors and all, they take up the case of the center government and so on, and not the private parties. And so means the government will provide them with the fund, means the salary and anything that they take up from the government. Court side have applied only after it is submitted to. E-court side will have the echo in the voice. Maybe that's because we are using two. I think
Different devices
maybe that
simultaneously.
also.
Yeah, yeah.
Malicious intent for quashing is taken into consideration if it has to be quashed, the intent is taken into consideration. Okay. If arrest is made without a warrant, that means it's cognizable offense. So remand illegal, as in if it is as per the law ki 15 days ke liye, if the remand is taken, if the police is taking custody for 15 days and all, it won't be illegal in that case. They cannot exceed the police custody ki 20 days ke liye rakh liya, 25 days ke liye, then obviously magistrate will flag it, and even you can also raise voice against it in the court of law itself. Because maximum police custody is allowed for, is still 15 days ka period. Okay. Quashing wala comes under trials, and if we'll start discussing this, will take a lot of time. Trial wala stage is completely different. As of now, you are coming at inherent powers of the High Court and so. So that is completely when that is the trial wala period. So we'll start it now, so it will take more time to finish it up.
ऑल्सो संतोष, ये जो 2 वीक का पूरा वेबिनार होने वाला है, इसमें एडवोकेट्स भी ज्वाइन होंगे वो एक्चुअली प्रैक्टिस, राइट? सो दे वुड बी बेटर टू एड्रेस सच अ क्वेश्चन.
And yes, but answering to this, of course, quashing power which is given to the High Court. It comes under inherent powers of High Court only. So of course they will check everything. Whatever offenses you are stating, the charges that you are stating, whether it actually matches, whether the entire thing they will read. Judges will check everything that's there. Whenever you are taking a particular case where you're wanting to question FIR. 15 days is cumulative. It is one time only, which can be taken up with any time between 60 and 90 days. स्वप्न. एक बार में police will take the person and will put the accused person in the police lockup for 15 days. Okay. Yes, default bail is granted after 60 and 90 days. If charge sheet is not filed within this respective time period, the magistrate will grant bail. Okay, so I think the queries are also addressed here. Okay, anything else? So Jayan sir, Kalpesh, I think they are done with the queries or so. We'll also be like wanting to send the slides to
Yeah,
all
yeah,
the
yeah.
attendees. So
Yeah, we are done with, I think, most of the
Yes.
question.
yes.
Let the other resource person take over, because it's starting from basic of criminal law. Today you talked about FIR and with the
Hmm. Hmm.
theory part and practical part also. The more will be discussed in the upcoming session. So I
Yes,
request
yes, yes,
participants,
yes.
please.
That's why
Otherwise,
I'm not fully looking after the trial wala stage, because it will take a lot of time if we'll start discussing that. I get that.
जी.
Okay. So, okay.
Right.
So, anything else, sir, or should we wrap it up? Because we have pretty much addressed all the queries.
Yes. Thank you very much, madam, for joining us today and making this session possible. It's really great experience as an organization. We have to invite Phenology legal team, and our most of students used to watch your videos during their student life, and many people, I think so. It's almost one whole batch of 5 year BLLB passed by watching your videos. So it's really a privilege to have you all. Thank you very much, Team Phenology and Priya Jain Madam for joining us, and thank you very much, Kalpesh Gupta sir and Hiranshi Madam for providing guidance to conduct such session, and Honorable Mr. Justice M.R. Shah sir and C.K. Thakkar sir for your valuable guidance, your valuable things. Thank you very much. Thank you all for joining us and making today's session possible.
Thank you so much, sir.
thank you,
We
thank
would
you,
also love
thank you,
to have the feedback of the students.
Thanks. Thanks.
thank you.
Thank you so much, and we are also looking forward to have such insightful, informative session.
Yes, yes.
Right?
In future, we'll keep in connect, sir.
And for all
Thank
the participant, I hope it was insightful. It was worth your time. I can see lots of reaction. Thank you so much. Thank you so much.
Thanks.